Welcome to the Afterspin, opinions from thought leaders in our state. I want to ask John Hood and Rob Schofield. Gerrymandering in North Carolina made its way to the U.S. Supreme Court, with the 9 justices being asked to determine if political gerrymandering is acceptable. Justice Ruth Bader Ginsberg asked what we believe to be the central question. Does one person have one vote that counts equally with others if the impact of her vote is reduced based on her party affiliation? How would you rule on that question? And could you get any sense of how the court might rule on this later this summer? Rob Schofield.
Well, I know how I'd rule. I think I'd be with Justice Ginsburg, who's going to vote, I think, at least with 3 other justices to say that this is unconstitutional, that we've finally going to draw a line and say partisan gerrymandering. We've gotten to the point with modern digital technology that it's ridiculous. It ought to be unconstitutional. There are some standards that were articulated very well by the attorneys for the Southern Coalition for Social Justice about how we could identify areas where that's actually happening. As to what the court will do, who knows? It's going to come up probably to John Roberts as to whether he wants to have this be the legacy of his court, that he's going to
This is going to be a 5-4 decision one way or the other?
You know, nobody knows for sure what Kavanaugh is going to do. We suspect the other 3 conservative justices will go the other way. But I mean, this is going to be the legacy of this court. If this court is going to officially bless partisan gerrymandering of this kind of extreme nature that's happening in North Carolina, that happened in Maryland, I think it's
happened all over the United States.
John,
how do you answer Justice Ginsburg's statement here, or question here?
Well, I think she's completely going in the wrong direction, and that would never succeed as a judicial standard. Let me give you an example. Say you're a Republican. I was recently in Chicago. You're a Republican in Chicago. You want to vote in the mayor's race for a Republican. It doesn't make any difference, or a city council race if we're going to get into districts. It doesn't make any difference how those districts are drawn. If you're a Republican and you want to vote for a Republican, your vote does not count very much. You better choose one of the Democrats, because your Republican candidate will never be elected in the city of Chicago. Now, you cannot argue, well, therefore that vote is worth less. The federal Constitution requires intervention. You could draw some squiggly lines and bring in other parts of the state. That's a silly standard. A better argument was Stephen Breyer's argument. He was trying to get at, is there some way to distinguish between really extreme cases and sort of run-of-the-mill, plus or minus 5? Now, I'm not sure he got there either, but that was actually a more productive line of inquiry for the plaintiffs than Ginsburg's standard, which is really impossibly meaningless.
So, well, go ahead. I'm sorry. Ginsburg wasn't articulating that, though, as the legal standard that the court should adopt. She was asking, I think, really a rhetorical question. The standard that makes more sense is the one, again, that Allison Riggs of the Southern Coalition identified. There's a 3-pronged test. It would make, or maybe something along the lines of what Breyer was trying to describe. I think her argument was almost like a political argument she was making with that question. She wasn't identifying that as the standard that we had to enact.
Unfortunately, that is one of the bases of the lawsuit. Is the reason why they're in federal court at all is the argument is your vote does not count the same. It violates equal protection if you are gerrymandered, if you're a Republican into a Democratic-leaning districts or a Democrat in a Republican-leaning district. I simply do not think that standard will work. I don't think the Supreme Court will ever find that. That is not the same thing as arguing for redistricting reform, which we should, of course, do. I just don't think the U.S. Supreme Court, based on First Amendment claims and so forth, and Fifth Amendment claims, should be intervening in this way.
Isn't this kind of like, I can't remember which Supreme Court justice said it, but about pornography? I can't define pornography, but I know it when I see it.
That's what Breyer was trying to say is, well, yeah, there's a whole lot of this that's hard to distinguish between pornography and erotic film, but maybe there's these things way off in the fringe that we could distinguish between, and that, I think, is, again, a more productive line of inquiry that might have gotten, for example, Anthony Kennedy. I'm not sure it's going to work in this case, but I do think he was asking the right questions.
What's your prediction?
I think that redistricting reform is going to happen in most of the states in the coming years, but I do not think it will be because of federal court action.
Your prediction?
I think there's a chance. I actually do think there's a chance the Supreme Court will articulate some sort of a standard to say that you can't go past this line. But it's a tough line to draw. And I think that, again, the line that was articulated by the Southern Coalition about a 3-pronged test, is it specific to a district? Has it got a durable and lasting effect? There's no other explanation for how the district was drawn that way. I think that's a standard that could actually be applied.
I've just got to chime in. Call me a doubting Thomas. This court has had the opportunity to be able to rule on this many, many times and has managed to dodge the ball.
Okay, Tommy.
Yeah, there you go.
You may be right.
Thanks for watching the Afterspin. We'll have more video all during the week on ncspin.com.